and be happy. You're here. I mean, we have to understand it's not going to happen. The law won't change unless we put our bodies on the line and demand it. That's how every great change has happened.
Mayor Bergen, will you lead us to the state capitol?
You know, that microphone needs to get...
It's not on.
Something's wrong with it.
It's not working.
Like something's wrong with this system.
Just speak louder. I think it's on. It's on. Yeah, it's on. Yeah, just
Okay, I guess we gotta turn it up or something.
Hi, I'm Amber. First of all, I want to say I strongly support what you're doing. It's fantastic. And also, I understand all the issues that the City Council is facing, and I really hope and strongly encourage that the City Council retains CELDF.
Can you have a question for us, please?
Yes. My question is about timing. The only timing that I've heard is the original proposal was slated to begin January 2019. That's what the oil company wanted. I know litigation can take years. I don't know if the oil company is aware of our strategies. I'm just wondering if the proposal is pushed back, or if it will be stayed during litigation, or basically kind of what the time frame is that we're looking at.
So there's a lot of variables in all of that, but the biggest variable, at least from our perspective in terms of personal experience, has been if there's a defense of an ordinance. So generally this is the way it happens, is that a municipality will pass a law. The law interferes with the activity that the corporation wants to do within the municipality. And it's usually a community bill of rights, so it's linked to rights, about expansion of civil and political rights at the local level. The corporation will come in and sue. And depending on how aggressive the corporation wants to be, which is usually dependent on how quickly they want the project to move, they will file for something called preliminary injunctive relief, so a PI. And a PI actually strikes the ordinance in the short term to allow the corporation to move forward with whatever project they're doing. If the PI gets denied, then technically the ordinance has legitimacy. I mean, it's valid, and it's sitting there stopping the project from moving forward. So it's dependent upon that early relief that's requested by the corporation. And the corporation has to make their own decision about whether to sue. And so that comes at varying times. For some of our communities, it's come 2 years before the corporation was going to do something in the community because they preemptively see it, and then they want to mow it down before they come in. So they want that length of time preemptively to do that. In other places, they've sued a week before they wanted to come in with an understanding that they can then gouge the community for damages. Because if they have, concrete thing moving forward on the ground, they can then show the court that they were stopped from moving forward with the concrete thing and can ask for damages from the community. But it's important to underscore that point, which is that there's a real financial risk involved. And, at least one township in Pennsylvania, one municipal body that we represent, has publicly stated that they're willing to go into bankruptcy over these types of things. So there's no easy answer to your question. There's a lot of variables, but those are the things we've run.
Thank you, Mr. Lindsay. Just as a follow-up, for clarification, while this is tied up in court, if it moves forward, in the end, oil and gas companies could still drill?
Depends on the ordinance language and whether the corporation has a preliminary injunctive relief to actually relieve themselves from the burden of that ordinance.
Have you seen that happen in other municipalities when you're defending this, that they've moved forward with whatever?
No, and there are reasons I can't really discuss tonight for why the corporation doesn't move forward, but there are other variables that the corporation has to consider about operating in a municipality in violation of an ordinance. That creates problems for other things that they have.
Do any of those states have preemption in the state law? Whatever.
All of them. Yeah. So the Oil and Gas Act preemption stuff that you have in Colorado is pretty much across the board. I mean, it's the corporate boys at some point got tired of chasing after municipality by municipality, and so they went to the state. And that's how the state oil and gas acts were passed, was to across the board preempt municipalities, so they didn't have to worry about individual municipalities having to chase them. So in some ways, when we give talks, we talk about your government has been privatized. Yeah. Your governmental structure is privatized because it's about use of a public entity or institution for private purposes. And that's what preemption is. Our argument is that a community evades preemption because sealing preemption is unconstitutional. When the state puts in place a law that actually governs the ceiling of what a community can do in terms of passing standards or rights-based stuff at the base, that is unconstitutional in itself. Yeah. So essentially the claim that we run is that preemption, Dillon's rule, and corporate rights are unconstitutional violations of your right of local community government.
Thank you for coming, and I want to say thank you to everybody here for making this meeting happen. It certainly was not our elected officials. Yeah. It's so refreshing to hear the truth rather than platitudes like, let's regulate the heck out of it, take multi-pronged approaches, go out and vote, working together to fix the system. And that brings me to the first part of my four-part question. So one of those platitudes we get a lot is, we were sued, or sorry, we banned it, we were sued, and we lost. End of story. And it sounds like you're familiar with the history of what happened, but my understanding was that the community was part of that lawsuit and it was going to be fought on a community rights basis. But there was something that happened in there where the community was dropped from the lawsuit, and so it was just strictly fought on preemption and not a community-based argument. And I feel like that gets glossed over every single time the council tries to say, we tried,
I'm so sorry.
we were sued, and we were lost.
You've got plenty of time.
I know, but
That was
I
the
want
first part
to
of
make
four.
sure.
I'll get through it quickly.
We want to hear
Council has hinted that their hands are tied until a permit is filed, and they'll deny any permits. What are your thoughts on this strategy? Also, are you familiar with Mom's Clean Air Force, a project of the Environmental Defense Fund? They support market-based solutions, which to me sounds like a front group. Have you ever crossed paths with them, and are you aware that this is the mayor's day job, and is there a conflict of interest here? Fourth part of the question is, well, it's not a question, it's just a statement. There was a 5-year-old named Mason who was here tonight who had this letter for the mayor. He wasn't able to deliver it. I met him, and I told him I'd give it to you before. So here you go.
So quickly on the 2013 charter amendment, it was actually worse than that, which is the way this works. And it took us a while to learn how this works because it's a pattern. Now we're into pattern recognition, but the way it works is that when the corporation comes in to sue over an ordinance, they don't sue the people of the community. They sue the municipal corporation. So Lafayette, the city, is actually a municipal corporation. That's what Lafayette is. And so when the corporation comes in, they sue the municipal corporation itself, which means that you are left on the outside looking in. The dangerous piece of this is that when the corporation sues the municipal officials have attorney-client privilege, of course, with the municipal corporate lawyer, and they can do a deal with the corporation without anybody in the community knowing. So we've had this happen in a couple of communities where the corporation has sat down with the municipal officials and hammered out a deal to repeal the ordinance and then pull the lawsuit. Because you don't have any idea what's going on. And these guys, not these guys, but elected officials and an attorney are locked into attorney-client privilege. It's not something they can share outside. It's locked in. And so you have no idea what's happening between the corporation and the municipal corporation, the private corporation and municipal corporation. To solve that, because we think the people that were responsible for driving the law into place in the first place should actually be at the table during the litigation. Makes sense to us. And most of the time the municipal officials, although not in this case because it's a municipal passed ordinance, have been on the sidelines watching these ordinances pass but don't like them. Because it puts them in a bad position of, perhaps fiscal loss and other things. And so a lot of times the municipal officials don't like the law that's been passed by the people. So they want to not exclude the people, but they want to hammer out a deal with the corporation to make the thing go away, the lawsuit go away. So the people are not in the lawsuit in the first place. They're on the outside. You can get into a lawsuit by doing something called intervention. You can intervene in the lawsuit and become a party, which is, we represent many intervening parties to try to get into the lawsuit. The problem is that sometimes that intervention is influenced by the positions of the parties that are already there. And so in 2013, in the Lafayette case, which we followed very closely, that the citizens group wanted to intervene to raise those rights-based arguments. But the city council voted to not let them into the case to make those arguments. And the other entity that voted the same way was COGA. The Colorado Oil and Gas Association also wanted to prohibit the citizens group from coming in. The judge ruled that the citizens group couldn't come in. So it was cut out of making the arguments that are along this strategic line at least. And we're left making other arguments. So I think that's the biggest part of your question. I don't know anything about
I've asked that a lot, and that's the first time I got a straight answer. Thank you.
Yeah. I don't know anything about Mom's Clean Air Force. Sounds good. Hands are tied, deny permits. You have to understand that when denying a permit is suable, that you only have certain discretion under the authority that you have within the city, and not talking just about Colorado law, but other law, is that when you put a regulatory system in place and you issue permits, those permits have to comply with the authority that you have as a municipality to actually carry out the regulatory program. And so they're suable too. The corporation could come in and sue over them saying, you didn't have the authority to deny the permit. And what I've seen, of course, is these permit hearings where the corporation will load them up with 100 experts. And then the city says, well, wait, the traffic's going to be too bad and we're going to deny a permit on traffic grounds. And then the corporation sues the municipality and says, well, we brought in 50 experts to say the traffic wasn't going to be a problem. And then those experts carry the day and then the permit is issued or overturned or whatever. And so that's just the way shit works. I mean,
So I'm hearing that's not a good strategy.
well, it depends on what the underlying law is. But if it's a standard regulatory thing, you know, the zoning regulations are not bans. They're not bans. They're actually about allowing an activity to take place and then trying to regulate it. Regulated is a verb. It means to regulate an ongoing activity. So it means allowing the activity in and then trying to regulate it. Thank you. Yeah.
I'll go to a constituent question here that was sent in. The Climate Bill of Rights states that laws adopted by the people of the city shall only be preempted or nullified if they interfere with protections provided to the people or ecosystems of the city by international law. Can you give an example of international law that interferes with the city of Lafayette law?
I don't understand.
All right, good. We're gonna does CELDF carry malpractice insurance, and if so, what are the limits of that insurance?
Yeah, we refused. We did not answer that question as it was posed by the city council, if I remember correctly, just because we don't share that information in a public forum. But we're happy to share that with the city if the city decides to retain us for this particular purpose.
Hi, thank you for being here. I have two questions. The first one is that I'm sure you're aware that 2 months ago, New York City sued the 5 biggest oil companies for damages for climate change. What do you think of that lawsuit? That's my first question.
Hey, the more the merrier. I've read the complaint. I don't think they're going to win, but it doesn't matter. I mean, it's, bring it on.
Okay, and then my second question is this. I guess as you know, in Colorado, local communities have lost under state preemption doctrine and Dillon's rule. It's clear to me that we won't get any help from the state courts or the state Supreme Court here. So why not sue in federal court and ask for a TRO and just fight it out in there?
Well, when you ask for a temporary restraining order or some kind of injunctive relief, it's going to be based on some kind of law, underlying law that the municipality has. And to get into federal court, you also have jurisdictional requirements. So not every case can be brought in federal court, only those raising federal constitutional questions. And these do. I mean, the Climate Bill of Rights does when the corporation defends on the basis of constitutional rights or sues in the first place. But I think it's always better to, it's certainly cleaner and more controllable if the corporation as the aggressor comes in to sue you. I mean, that's the best situation that you want. If you're going to be sued, is to be sued in that situation and then either litigate in federal court, because most likely you're in federal court already. The other secret nobody ever tells you is that the reason why the corporations sue is so they can get you into federal court by bootstrapping the federal civil rights stuff. Otherwise, you end up in state court which most of the company lawyers at least believe are biased towards ruling on behalf of the municipality. That's turned out not to be true here. But usually they'll elevate it so far up so that it's the furthest away from the community. And federal courts were the ones that invented corporate rights. We also have to remember that too. So starting back in 1819, it was the U.S. federal courts that began to bestow a series of constitutional rights onto corporations, starting with the 14th Amendment, the 5th Amendment, and the 4th Amendment, and everything else. So it's not exactly a hospitable place to be, and they know that.
So are you saying you're going to fight it out in state court or federal court?
I don't think any decision has been made on any level with that yet. People misunderstand our role as well. We're just the law firm. So the municipality gets sued, then the municipality calls us and says, would you represent us, and are you the right counsel to do so? Some of the interview questions have been asked tonight. But the municipality has to decide first whether they're going to defend the lawsuit or not. That's a political decision that has to be made. And then we get called in to help. But it's important to understand that this movement that people talk about, which I think is at the beginning of a movement, it's kind of been there. But that movement's being carried by regular people and elected officials in very small communities who are standing up to say no more, we're not going to do this anymore. And so people blame us, but all we do is support their movement with a constitutionally based argument. That's what we do. Yeah.
Hi, Mr. Lindsay. Thank you for coming and speaking to our community. Is that better? Okay. At the last council meeting, in the presentation by the attorney, he repeatedly used the term extent practicable when reading all the proposed regulations. This term seems to imply that the council members will no longer be in a decision-making loop, leaving the oil companies to make decisions and leaving our community completely unprotected. Am I correct in thinking that the term extent practicable leaves crucial decisions at the drilling site in the hands of the oil companies? And could you please tell us the implications of this term? Also, when the pressure comes from oil companies or the state, how would your approach and the Community Bill of Rights be stronger and better versus regulation that could possibly exclude local communities' decisions? I have two more questions. So what could a partnership between CELDF and Lafayette look like, and how would our community members be involved in this?
So on the first one, it's not really a term of art, this extent practicable, but basically means we're going to live within the existing authority that we are recognized as having. So if you have recognized authority to do 250-foot setbacks or whatever the authority from the state is, it means working within those areas of authority to do whatever you can do to make the best of the situation. Not to mince words, but to make the best of the situation, live within the authority that you've been delegated and that the courts have recognized, and then do the best possible job within those parameters.
But who decides what the best possible job is? Who's making that decision?
Well, it's kind of been defined for you in some ways by the courts here in Colorado and the legislature, and the fact that you were sued by, was it the governor? Did the governor sue? Yeah. So those parameters have pretty much been established, that communities lack the legal authority at this point under traditional law to ban oil and gas extraction or even ban fracking within a community. That's the law. So when we talk about the extent practicable or working to the extent practicable, it means accepting that and then working within the regulatory stuff to try to regulate it the best that you can. In other places, what you hear a lot from the environmentalists, the environmental groups, the big ones, is that they always say, well, we use the regulatory stuff and we allow the activity in, but we're going to try to make it too expensive for the company to actually operate here. So we're going to charge big permit fees and all this kind of stuff. I've seen case after case over the last 20 years where the corporations, if it becomes too expensive for them to do business, they just come in and sue. And when they sue, they use the same legal doctrines to pare back the regulatory framework to actually get back to the bare minimum where it's cost effective for them to do operations in the community. It's a business decision for them about where they challenge stuff, and where they do stuff, and where they're willing to abide by the local regulatory stuff. But all that's established by court decisions, and in this case by the preemption law, the Oil and Gas Act at the state level, and all that kind of stuff. So that's been pretty well defined here, and it's only been well defined because communities have pushed. Communities pushed, and then the court slapped you down. That's how it worked. And in the midst of it, the state came after you. There's very little difference at this point between the state and the corporate boys. They're almost one.
Yeah.
I mean, they're kind of glued together, and so when we say you have a democracy problem, that's what we mean. It's all one. As for partnership, I don't know. The city has to decide which direction they want to go. Do you want to fight? Do you want to do the regulatory stuff? Do you want to enforce? I mean, all that stuff is still up in the air, and it's a political decision for the council to make. We've reiterated our offer to assist in whatever capacity, even if we're not chosen as council, which we don't take offense at, that we're happy to help whatever lawyer the council might hire, as long as if that council decides to defend the ordinance in the mode of right of local community self-government stuff. So.
What I love about grassroots organizing is that we can be open and honest and do the fussing and discussing and deal with the warts and everything just as it is. And I love the answers that we're getting and the honesty, and I hope the city agrees to retain.
Cliff, what's your question?
Anyway, the one question I have is state constitution says all political power derives from the people. That one seems to be getting lost here. Can you explain how that one's getting lost?
Yeah, those provisions are found in almost every state constitution. And in fact, in our research over the past couple of years, we've actually found that the new constitutions that came into vogue or were adopted and ratified in the 1800s, Congress actually passed enabling acts that required them to embody the Declaration of Independence in those new constitutions. So in other words, a federal requirement that this right of local or right of self-government be inserted into each of those new state constitutions. But those provisions are generally just seen as frippery. I mean, by the important people, by the lawyers and the judges and the law professors.
They're powerful words to me.
People died and bled to drive them into those constitutional frameworks, and now they're ignored. It's like the Declaration of Independence, that those first provisions that talk about all powers in the people, and we have a right to abolish government. Remember those provisions? That doesn't work. I mean, our argument in court is that this governmental structure doesn't work anymore. And the people are standing up to actually abolish it and replace it with something else, a new structure of government, which is supposed to be our birthright under that formulation. But the courts have actually held that the Declaration of Independence is unenforceable and non-binding, that it doesn't exist as an independently enforceable document. And those words in the state constitutions are statements of principle, but are not binding either. A lot of our work has been to resuscitate those principles into being real life things. And I think that's a necessity, because otherwise you don't have an anchor of government being by the people, for the people, and all the stuff that we say on July 4th.
I served in the National Guard to uphold those sort of things. So anyway, if our city council members aren't willing to do the right thing, I don't know about the rest of them, I'm certainly willing to carry recall petitions for the one that
So,
I'm going to go to a constituent question here.
I'm a constituent.
Yes, I know, but there are 16 people who aren't able to.
There's 160 back here.
I understand. Can we,
Okay, you have the floor, Mayor. Go ahead.
Thank you. It says, can you explain how corporate rights affirmed by the Supreme Court, such as equal protection clauses of the 14th Amendment, unconstitutionally violate the rights of the residents of the city of Lafayette to local community self-government?
Right. It's a complicated question, but it's the first count that comes in against you when a corporation sues your community to try to nullify a local ordinance that you passed. And because corporations are persons under the U.S. Constitution, and people may say, what's that? Well, corporations became persons under the U.S. Constitution as early as 1819. So, just to simplify, because a lot of this is just jargon, but the U.S. Constitution Bill of Rights recognizes certain constitutional rights for people, for persons. That's, First Amendment free speech rights, and Fourth Amendment rights against unreasonable searches and seizures, and due process rights, and equal protection rights. In 1819, corporate lawyers began running an argument that corporations were actually persons protected by the use of the word person within the Bill of Rights to the U.S. Constitution. So a case called Dartmouth College in 1819, and then over about 80 years, the Supreme Court and other appellate courts began granting one right by one right to corporations as the cases went through the courts. So in 1886, the famous case came up in which a railroad corporation sued a county in California and asked the court to recognize that the corporation had equal protection and due process rights under the law. What does equal protection mean? Well, equal protection means that when a law is passed, it's applied to each of us equally, to each person equally. Corporations, as persons, have to be treated equally by the laws. Why does that matter? Well, we found out why it mattered way back in early 2000 when communities began banning corporate farming in Pennsylvania. So at the local level, ordinances that prohibited corporations from farming. And it was to stop the factory farms stuff from coming up. They banned corporations from farming, but of course encouraged family farmers to farm because the ordinances just dealt with corporate farming. They were met with a lawsuit, the first count of which was an equal protection claim, which said we are a corporation, we are a person under the Equal Protection 14th Amendment, part of the U.S. Constitution. This law treats us differently from individual farmers. It bans us as corporate farmers, but doesn't ban individual farmers from farming, and therefore violates our equal protection constitutional rights. You violated our equal protection constitutional rights under the 14th Amendment. So that's a real-life example of how it actually works. It takes away an option of yours to actually treat corporations, in this example, differently from individuals. So it doesn't matter what your value system is anymore. If your value system is about small family farms, what it says is you can't use laws to actually carry out your value system. It will punish you if you attempt to carry out your value system into law, because the law will punish you because the corporations can come in and sue you. And again, because of the constitutional right that you violated, they can sue you for damages as well as attorney's fees. The attorney's fees in the Grant Township case alone are now up to about $600,000. $600,000 that the oil and gas company has spent to hire the law firm to sue the township to claim that their law against frac wastewater injection wells is unconstitutional. And under the law, they're allowed to attempt to retrieve that from the township. The township is 700 people. 700 people, and so, you're in a situation where the law is not on your side. The law is someplace else. And the fact that the law is there can be traced all the way back to the earliest constitutional stuff, where the founding fathers didn't trust you. Okay? The founding fathers thought that most problems were a result of too much democracy, right? And so they took commerce and they lifted it up to the federal government level. And it's that commerce stuff that's reflective of how the federal governmental system operates, which is that commerce is so important, it's got to be put above the ability of a majority of people to actually adopt a law to interfere with. That's how the constitutional structure is built. So when we talk about this not being an individual problem about an individual company or an individual frac well or whatever the individual problem is, it's not, it's structural. And we all come through our own personal individual evolution to figure out what we were taught in grade school that's completely wrong about how the system works. And it slaps us in the face. And for us, it took 12 years. For others, hopefully it takes less. But about how the country is actually built, who can actually pull certain levers against others. And what you find is that we live in a particularly nasty place. That this nasty constitutional structure means that you're on the losing end of all of these fights unless you fight differently, right? That's the key.
What about the comments?
So first of all, I'd like to speak as a registered nurse, both working in the ICU, working in the emergency room, and working in primary care. I have to take a disagreement when we talk about the worst case scenario here, because we're looking through it through a purely legal lens. The worst case scenario is people die. The worst case scenario is after everybody that is on the city council here right now is come and gone, that people are dying of cancer, neurological disorders, birth defects, and they will not be held legally responsible for their actions. So let's try to reframe this. This is not, we're not talking about doctors and nurses here. We're talking about politicians and CEOs and lawyers. So that's a very bizarre framework. And secondly, when we're talking about the use of government, state and federal government, to disenfranchise people, there's a famous quote here, and it says, he has refused his assent to laws the most wholesome and necessary for the public good. That is the first charge against the King of England listed by the colonists again in the Declaration of Independence.
Yeah.
So the question is, would we have asked the colonists to conform to the laws of the King of England? And also to Christine Bird, how bad does a law have to get before you are no longer morally capable of enforcing it?
Yeah, there you go. There you go.
Thank you for being responsive.
That was a question for you.
Oh, I'm not going to answer
me
questions
too.
for this year.
Me too.
No, I agree. It's, when the lawyers look at stuff, and you look at stuff from a municipal corporate standpoint, it loses all the humanity, which is, we believe that communities are not just the people that live there either, but also the ecosystems and the natural community that exists at the community level. Otherwise, we're saying that a community is just the two-legged ones. And so when we argue these things about community self-determination, it's not just the self-determination of the people that live there through their political entities, but it's also self-determination of the ecosystems and the natural communities that depend on the community for their survival.
That's what the Indians preach.
Here's another question. I would like to know whether, in the opinion of Community Environmental Legal Defense Fund and Thomas Lindsay, are there any insurmountable legal deficiencies in Lafayette's Climate Bill of Rights? Also, please, they're asking about who you would hire to represent the city.
So, I am not licensed to practice in the state of Colorado. And when I'm not licensed in Ohio or Washington State or Oregon, the other places where we do work, but we maintain staff who are licensed to practice in those areas. In Colorado, we've been in a contract relationship with other lawyers from time to time. So, again, this is dependent on 8,000 things falling into line, including the city council deciding that they want to enforce the law and going through those steps. But if the council turned to us, if the municipality turned to us and asked us for help, we would retain one of those lawyers that we have retained before to provide representation, and then tie them directly into our network of lawyers that we have doing this work.
Sorry, and there's this part about the insurmountable legal deficiencies.
Yeah, I never know how to answer those questions. What's insurmountable? Women voting? I mean, African Americans not being owned. I don't know.
Making marijuana legal.
It's making marijuana legal.
Thank you for being here, Mr. Lindsay. I have a kind of a three-part question. You've covered a lot of it already, but wondering how widespread, if you could describe a little bit more, you've talked about Ohio and Pennsylvania, if you could describe for us a little more so we could have a better kind of human understanding of what happens. How many other kinds of communities across the U.S. are having this problem of having dangerous corporate operations forced on them? And which communities in the U.S. have said a clear no, as we're trying to do? What kinds of actions are being successful for them in some way? Because we hear things only on social media. If we're on activist sites, it's kind of easy to feel isolated. And the third part is, given the fact that no community in the U.S., as far as I understand, has ever had any effective protection from going with just the regulatory route. If you could give us your definition of how establishing, codifying, and defending community rights, climate rights, and the rights of nature help us put real protections in place.
Sure. On the first one, we began our work in central Pennsylvania around factory farm operations. So big agribusiness corporations who wanted to put 25,000, 30,000 head hog factory farms into municipalities. It's where the community rights movement stuff started, which was in small rural municipalities in south central Pennsylvania. And we assisted them to pass these corporate farming laws, which we talked about earlier. And most of the time they worked in terms of the agribusiness corporation would look at them and then go someplace else. That was the beginning of how it operated. But of course, as people reminded us, those folks are going next, the corporations were going next door into other communities, and so we needed to help those communities as well, and that's really how this started. And then we started getting calls from other folks that wanted to understand more about the structure of how this work began and how it evolved. And so we began teaching these things called democracy schools, these 2-day trainings for lawyers, municipal officials, community activists, to basically start talking more and more about what these folks were doing in central Pennsylvania. And the work spread first to New Hampshire, where they're facing off against a number of issues like corporate water withdrawals, Nestle Corporation coming in to take water from some of these communities. And those communities started working against those corporate operations. There's a huge project in New Hampshire called Northern Pass, which has split that state like nothing I've ever seen, but it's this huge power line to wheel power from Quebec down to the Boston metro area in Massachusetts. And the rural communities are up in arms about it. And then Ohio has been active. Ohio mostly around fracking issues, oil and gas stuff. That's what's been driving the whole thing. And then Washington State, my home state, there's been activities about Bill of Rights being placed on ballots, and then Oregon, first community Bill of Rights passed last year that banned pesticide spraying, aerial pesticide spraying, within counties where it's been used intensely by the timber industry, where they spray actively. So there's a lot of people, 200 communities in 10 states who are with you, who have begun doing rights-based organizing on their own. And those folks in those states have given rise and forced statewide organizations to be created. So like here in Colorado, you have the Colorado Community Rights Network. In Oregon, you have the Oregon Community Rights Network and different entities. One of the most exciting things is that in New Hampshire, the constitutional amendment that you put forward here in Colorado, which would essentially legalize this community rights lawmaking model at the local level, was actually introduced by a bipartisan group of Democrats and Republicans into the New Hampshire legislature. And last week, a subcommittee of the municipal committee voted it out favorably, said it ought to pass, which is their reference point for putting it out there. Narrowly lost by 1 or 2 votes in the committee, but now it's going to go to the full floor of the House next week. So here's a real live thing that started in Colorado, because Colorado was the first state to put a constitutional amendment forward at the state level. And in Ohio, they've now qualified for circulation for the same kind of constitutional amendment. In Oregon, they have as well. And so the work is picking up in those areas. And I think that was about it. So the way it starts is that it becomes relevant to them what corporate rights means. In other words, this stuff is not relevant to folks who are not on the receiving end of a corporate project. That's what it takes, something moving in next door or something that impacts you physically and personally, and those are the folks doing the work, because otherwise it's not relevant. The structural stuff and the constitutional stuff isn't relevant unless you're faced with a harm.
Thank you. Can I just go back for 1 second? Something that you were saying about communities, and also to dovetail on what Cook was saying.
Go to the mic.
Closer to the mic.
Sorry, I wanted to dovetail on what Mr. Lindsay and Chris both were talking about, the quality of community, what a community really is. And I just want to say that I'm heartbroken. I'm this far from tears, and I have been for weeks because of this. A community, I've been really studying what a community is, and it's the connections between people. It's the way that local business and residents work together. It's the way that we value our open space. It's the way that we sustain the wildlife. It's the way that we have dog parks where dog owners meet each other. You can't have any of that when fracking comes in, when they're by the schools, and they're by the dog park, and they're by the recreation center, they're by the graveyard, they're in all the open spaces. I just want to ask, have you ever come up against a situation like this where the city elected representatives can't seem to find the gumption to stand up for that, stand up for the survival of the community? I mean, it's really about survival versus, gosh, what might happen legally or financially. It's death to a community.
Right.
Good enough.
It's that,
Non-criminal.
it's that feeling of crisis that not everybody shares. But I think the best line ever, I was in New Hampshire at a community meeting, and people there were putting up an ordinance that would ban corporate water withdrawals, that ban Nestle from taking water within the community. And one of the city council, one of the town officials said, who was against it, he said, well, there's not gonna be any jobs if you bring this in, which is the standard thing, you know, there's not gonna be jobs if you pass this. And somebody in the back, this old guy, who's just sitting there quiet for the last hour, he stood up and he goes, ain't gonna be no jobs if there's no water. shut the whole meeting down. It was like, and then they passed the ordinance.
Good point.
Another constituent question. I'm not sure if I understand this from you. Do you have any experience with or opinion on the implementation of reasonable impact fees under Colorado revised statute, blah, 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 intended to defray the projected impacts of violations of the Lafayette Climate Bill of Rights? Would establishing impact fees undermine the intent of the Bill of Rights, or rather create a viable means for ensuring that the enumerated rights were respected in a manner consistent with the state law? The purpose of this article to permit each oil and gas pool in Colorado to produce up to its maximum efficient rate of production, subject to the prevention of waste consistent with the protection of health, safety, and welfare.
Next.
All right, I'll ask you one more. What does it look like? Higher taxes, fewer services, no community events if the city is sued and loses. Example, cities that have been through this. What has happened in other cities after this provision failed in the court system?
The short answer is nothing. Whereas we counsel folks on worst case scenario has not occurred to date to any municipalities after 15 years of doing this work. However, the caveat is it could happen at any time. And so I think that's the.
And can you kind of reiterate what's worst case scenario in your?
Well, worst case scenario is you're on the receiving end of a lawsuit that asks for multi-million dollars in damages for locking up the oil and gas asset. And you get hit with attorney's fees. And you're ending up on a receiving end of a damage award of a couple $1 million, $20 million, $50 million, and your insurance company runs away. And then the municipality has to decide whether to file for municipal bankruptcy or not. I mean, the oil and gas industry, which tapes every talk I give. I mean, when in rural Ohio, somebody shows up with a camera and they're actually taping the talk I give. They pull stuff out of context, they pull words out. It's like, oh, CELDF wants communities to go bankrupt. Well, no, but that's the last thing we want, because I wouldn't want my municipality to go bankrupt. But at the same time, when we give counsel and advice, we have to acknowledge that that's a possibility. It's not a desire, but if you go this route, it's a possibility. And it hasn't happened, but that doesn't mean it's not going to happen. And the oil and gas industry is very aggressive. They own you. They own you in Colorado. Colorado is like the worst. I mean, the states I've been, except West Virginia, I think beats you by a hair. But this is the worst. They own you. I mean, you know, and you got to, I mean, I'm not being, just to be blunt, you got to decide whether you want to continue to be on your knees or not. I mean, that's, because that's where you are. You either, you know, die on your knees or you fight. And those are sometimes the two choices.
Thank you for standing up to the corporate power. I've been aware of CELDF for a long time. I've listened to Richard Grossman, been inspired by him. I'm not going to take this out of context. At one of your democracy schools, I remember hearing you say that you said, rather than ask what you can get, why we should be asking, what do you want? Right? And I know you're with the Community Environmental Legal Defense Fund, but the corporate power knows no bounds. This power's out. And when I was campaigning for that amendment, community rights amendment, it spelled it out. We could enact any law, right? So those laws could be from, you know, economic, political, any areas. So not only are we going to be stopping this harm and elevating the environmental, but there's a host of other things, many other things that we can do with these community rights amendments, right? So where does the Climate Bill of Rights, lead into other areas like those? That's the first question. I think mainly I wanted to ask the mayor, and I understand it may not be over time here, but what are your criteria and factors on this decision-making process that you can put forth into the public, enumerate as well as qualify on what you expect to see besides an overwhelming popular demand, as well as the ethics behind this? Have you laid out any criteria in that decision-making process?
So the Community Bill of Rights model, strategy, whatever you want to call it, has been used in other places. We worked with the Occupy folks to develop an Occupy Bill of Rights. We've worked on eminent domain issues, on labor issues. Most people don't realize that when you work for a private company and you cross the threshold into the private workplace, you lose your constitutional rights when you set foot in the private workplace. And so a labor bill of rights that would establish or reestablish those constitutional rights in the workplace. Homeless bill of rights, I understand, is beginning to move as well. And so you're right, it's housing issues, affordable housing issues. My home city did put a bill of rights on the ballot that had housing issues and healthcare issues and all kinds of stuff. And I think it's time for those to happen.
Yeah, a quick comment. Authority has a root word of author. He who holds the pen, and the community rights, we the people, hold the pen. We write the rules. So thank you.
Thank you. I guess I have a two-part question, and that is kind of the more I reflect on Lafayette history and kind of what you've been describing other communities who are organizing. It occurs to me that this isn't necessarily a liberal issue. This is an extractive issue. Would you say that's kind of the case?
I think so. I mean, the issues that we deal with in municipalities cross party lines. I mean, you got the honest conservatives who believe in local control, and then you have the Democrats who are issue-oriented who become advocates for local control. And so you kind of got this weird new political dynamic that arises in these communities.
Yeah, some of that contextual information. The other part of my question, or I guess another question is, to the degree that you feel comfortable, what's your take on Lafayette as a community and Lafayette as a city council dedication to the fight so far?
The only comment I can really make is the 2013 decision that we were very disappointed in, which cut out the interveners from participating in the case. That's kind of a no-brainer to me. I mean, it's, the people put the law in, the people should be allowed to defend the law as they see fit. And other than that, time will tell.
So in Colorado, you may know that there's a case pending at the State Supreme Court, Martinez, brought by 8 youth plaintiffs. And if everything happens that the Supreme Court upholds the appeals court ruling, then the COGCC will have to prioritize health and safety when issuing permits. And right now they are balancing health and safety with the profits for these companies. So would a ruling that was favorable to this Martinez case, would it help the Climate Bill of Rights, or would it make it irrelevant?
I think these kinds of cases are oversold as magic bullets of sorts. And so, like the Juliana case, I know that people have been following that one in the Oregon courts where the judge ruled a right to a livable climate. The Juliana case was youth bringing a case against the U.S. government on failure to do anything about climate change. And the problem with these cases, let 1,000 flowers bloom, first of all, because the attention and everything that they get is worthwhile in itself. But in terms of a legal remedy, they really fall short for me because the agencies are able to manipulate stuff. I mean, they have budgets and everything else. It's less to me about enforcing agencies or trying to force agencies to do stuff than about establishing rights as the baseline and going after it as a more direct piece of litigation or municipal lawmaking. So, every couple of years some lawyer says, hey, I got to create a new legal theory in this area. And I'm like, okay, but usually it's the same kind of stuff. And even though cases like Juliana have new stuff in them, I think the remedy is going to fall far short of what people's hopes and dreams are for actually changing something.
Yeah, I heard the governor, Hickenlooper, on the radio, and the interviewer asked him about the Martinez case. And he said, well, are things going to change? and governor said, oh no, we already take health and safety into account.
Hi, thank you for coming. Thank you, council, for opening up this session. I appreciate it. I certainly appreciate and love the idea of pursuing a legal strategy that's based on a more diverse ecosystem, human rights, local rights, natural rights. It seems to me that all laws should be infused with this idea if, we are taking an environmental perspective and understanding that the Anthropocene is going to burn our planet up. That said, it doesn't make sense to me why we wouldn't also use every single other piece of town council regulation on the books to update that with that viewpoint. And I'm thinking of, I know in Oklahoma there were some new laws recognizing the impact of earthquakes, which is new. It hasn't been written into any of the Colorado laws that I'm familiar with. I'm deeply disappointed with the what the lawyer came up with for new regulations, and that they were just modeled on Boulder. I think subjectivity was probably a good element, but I didn't see any new. I haven't read the whole thing, but I didn't see anything on earthquakes. Following up with the hope of the Martinez case, emphasizing public rights. Is there a way that you can legally, put into regulations on fracking, things about not allowing carcinogenic materials, not allowing poisoning of water, and all other kinds of defenses that recognize that? And why isn't that also a strategy? And if it is, what would you advise us to go ahead on all fronts to bolster this concept?
Yeah, I mean, generally we're all fronts people. I mean, that's, you do everything you need to do to protect yourself. But I think I've seen a lot of energy spent on that kind of stuff and almost zero spent on actually fighting the fight to end it or to stop something. Because no matter how you write the other stuff, you're still trapped within the state authority framework. So if you try to reach beyond it into things that take subjective bias or subjectivity on behalf of the council, you get pared back anyway because you're operating outside of the range of authority that you have via the state law.
Well, you're going to get pared back and sued doing the other strategy anyway, so why not?
Yeah, but
take it in the face on all sides.
It's funny when I say this because it always comes off funny, but it really matters how you lose. And that may not make any sense right now, but it depends on whether what you're doing is leading to something else or not. And the regulatory stuff tends to be a dead end. It's a one out and then done. But on the other stuff, it actually leads to a coordinated resistance that has a common theme behind it. And so we've been talking about legal strategies here a lot tonight, but none of it's a legal strategy. It's about putting forward a new legal theory, but using that to assist the development of a resistance campaign that actually stops oil and gas drilling in a municipality.
Right, so I still don't understand why that concept, which can be applied to housing and be applied to homeless rights, can't be infused everywhere else, because you're still coming up, we're going to get sued no matter what. I mean, there's no other way to exist. So,
yeah, I'm not sure where regulations usually don't have anything to do with rights. Rights litigation is a different basis. So one is a rights basis, one is a regulatory basis. So
okay, but I'm just thinking of it as either one is a law. So, I mean, maybe that's just too blunt.
I think it depends on there has to be a cohesive strategy and theory to all of this. Right. And I think that how do I put this? I think the only way that oil and gas extraction will stop in certain places, not necessarily Lafayette, but certain places, is massive, wide-scale civil dispute. Because I think whatever strategy is moved needs to complement that. And again, we're a law firm, we can't condone breaking of law, we can't do that. But at the same time, I understand. If it was my community, I would be on the front lines and I would be stopping the trucks from coming in. That's what I would be doing individually and personally. I think that's what it's going to take to stop it. So I think we have to understand that there's a possibility that if you enforce or defend the Climate Bill of Rights, you may find a judge who says, wow, that's interesting, and gives the room for it to actually breathe, which hasn't been found yet. We may have a judge in Pennsylvania that's allowing it to breathe right now, but it may be a judge here that allows it to breathe, whatever that takes. But I think at that point, if the thing falls and you're lacking that ability to ban, that authority to ban, that it's understandable if 1,000 people here began to sit down in front of the trucks and actually stop the drill rigs from coming in. That's understandable to me. Doesn't mean condoning it, but it's understandable to me. Because I think in the end, once the legal remedies are exhausted, the best legal remedies that we have to exhaust, then civil disobedience becomes the only option after that. And that may be the only thing that stops things from happening.
Thank you. And there's a constituent question here. Should we rely on the Climate Bill of Rights entirely on this front? Should we just assume?
It's a political decision to be made by the elected officials in each place about whether you want to try to run parallel regulatory procedures that would take some of the edges or the harm off of the drilling activities, or to run them in a sunset clause kind of way so that one replaces the other if one falls. I mean, those are other options as well.
And the second part is this a long shot?
Again, suffragism was a long shot. African Americans are a long shot. I mean, who cares? I mean, it doesn't matter, because you got to weigh the pros and cons and say, is this going to be successful or not? But in the end, it doesn't really matter, I don't think.
Thanks for coming. I have a few things. One is that I totally agree. Sorry, nobody can ever hear me. I totally agree that activism is the driving force. It's the thing that got us the regulations that we have today, and while they may not be the be-all and end-all, it's a heck of a lot better than it was when the first Earth Day started. 10% of the population came out into the streets and demanded a better environment. And for the next 20 years, every piece of major environmental legislation that came through, no matter who was in office, passed. So it is activism that makes the needle move. It's not the legal strategizing. That's it. Is there an opportunity?
Yeah, actually, I think I need to interrupt because sure. I don't believe that. I think today, and in the talks that I give, I actually laid out, which is that by almost every major environmental statistic today, things are worse now than they were back in the 70s.
Yeah.
There's been certain areas of improvement in indoor air pollution levels, and this is not to condemn the activists, because without the activists, things would be a lot worse, because they're frontline people. But sometimes when I say that, somebody says, well, rivers don't catch on fire anymore. And I'm like, well, if that's our measure of success, then we're in real trouble, because, it's that kind of...
But my point being that where would we be if those regulations had never been passed, right? So, and we're hoping to continue to move the needle forward. Is there a strategy that you've seen where communities have banded together to take this on? Do we have that opportunity here in Boulder County and the Front Range and throughout the state to band together and work on this together? And then also, is there a way to take the offense and not just sit here and wait to be sued and then defend ourselves? How do we step out in front and hit hard?
Yeah, so the talk of combining has happened in different places, and there have been in at least one place agreements of joint defense, that one would come to the defense of the other, kind of like the colonies during the American Revolutionary War. Yeah. And so that's happened. Most of it's been talk, but here there's an opportunity to do that, depending on what happens. As for the offense stuff, it's a great question. I wish I knew the answer, we don't wait sometimes. And the city, one of their options is to proactively enforce once things become concrete enough that there's a violation of the ordinance, is to move proactively. I think most of the fights have been defensive, where the corporation coming in and then getting tangled up in our stuff, in municipal stuff, and then carrying a lawsuit for it. But hey, we're not the end-all be-all. I mean, there needs to be better ideas from other places about offense, because right now it's not happening.
Thank you.
Yeah.
I was wondering if First, if there's anything that Lafayette could do that would establish more rights for citizens who did nonviolent civil disobedience, so that perhaps if there were a trusted evils defense that was mounted on behalf of citizens, is there anything that makes that more understandable, either in a political organizing way or legally? And my other question is, I was really happy, well, I can't really be happy about it, but well, there seemed to be good news in the lead lawsuit. There's something about, I think it's called the nuisance law in California, where I think a state court won maybe $1 billion against lead paint companies for knowing that for 50 or 100 years it was harming kids' brains and continuing to do it. So they sort of won, but now the paint and lead companies are trying to do an initiative that only costs them $6 million to make a new law that will say you can't require the paint companies to fix the houses. And so,
Shocking.
so
Yeah.
On the direct action stuff, I think there was a direct action provision in the original Climate Bill of Rights that got stripped out. But I think there's a bunch of ways to actually do that. Essentially you'd be looking at trying to insulate those folks who are involved in direct action from criminal prosecution, and how you do that as a municipality. I think the sky's the limit in terms of creative ways to do that if the municipality chooses to move in that direction.
well, with the fracking parts, we used to have a nuclear weapons plant that was leaking into the drinking water and the air, and burning plutonium at night and all that kind of stuff here.
Thank God that's not happening anymore.
No, it's happening.
I know.
Hundreds,
Not right now.
hundreds of people would do things. They would
Right.
non-violently sit down and block the roads and go to jail and march around the plant and all that kind of stuff. Sign petitions and then circle the state legislature with sign petitions. So there's lots of techniques, but, and then go to jail.
Yeah, we were just in Arizona where we were on close to California, where they were celebrating the Ward Valley victory. Where folks stopped the radioactive waste facility from being sited in Ward Valley. That was tribal, so that was at least 5 tribes coming together to do civil disobedience.
Where is that?
Ward Valley, California, Southern California.
Hi, I had 2 questions. One was a continuation of the non-violent direct action piece. It was removed by one of our counselors.
Gustavo Reyna.
Yes, and what I was wondering is, has a stipulation been included in ordinances and charter amendments in other states and other communities? And if so, like which ones and like what happened? And should it be added back to our ordinance?
Yeah, so the direct action stuff is relatively new. And it's included in our template ordinance stuff now. So when people call, they get the template ordinance, and then we have a conversation about direct action stuff. And sometimes it gets taken out, sometimes it gets left in. I think as a part of a longer-term strategy, because it's understandable to me that people are going to engage in civil disobedience when they're cut off from legal remedy, that it should be in the ordinance, because it's indicative of a long-term campaign that needs to be run. And I think the municipality has a duty to protect people who, when the legal remedies are shut off, feel the need, an understandable need to do other things. I think it's a legitimate role for the municipality to play, and I think it's the only entity with resources that has the ability to play that role. So I think yes. And I think there are other ways. I raised earlier that municipalities consider funding lawyers for the individuals that get arrested that are criminally prosecuted, or going back into the criminal code and changing the criminal code to decriminalize, it's a popular word here, decriminalize certain prosecution, or certain crimes. And there are ways to do that, like trespass, redefining what trespass means. So it doesn't include stuff done for civil disobedience purposes for broader political aims. It's been defined in other places. So there's lots to play with, but it comes down to political will. And sometimes the political will is there, sometimes it's not. And that's where you're stuck in a municipality.
There's a bunch of seats over there if anyone wants to sit down.
Okay, one more question that was turned in. In January, a U.S. District Court in Pennsylvania fined CELDF attorney that's you, Thomas Lindsay, $52,000 for pursuing frivolous claims and defenses in regards to French Bill of Rights costing Grant Township. The court said his legally implausible arguments included the purported invalidity of corporate rights and community self-governance as a justification for striking or limiting long-standing constitutional rights. What they're asking, what makes you think that the Colorado District Court would rule differently?
So we're passing a hat tonight.
Checks only.
There you go.
There's no reason for a court to rule differently. And I think that puts lawyers in harm's way, which is when we offer to represent, we're also putting ourselves in harm's way as well as the municipality. So there's a shared sacrifice or shared burden there. We are planning to appeal that ruling. We think that there's a number of reasons why it should be overturned. And that appeal won't take place until the substance of the underlying case moves through. The case is the Grant Township case. So the judge not only overturned 6 paragraphs of their ordinance banning fracked wastewater injection wells, to which the good people of Grant Township then, by popular election, adopted a home rule charter that reinstated those provisions that the federal judge overturned, and then got sued by their own State Department of Environmental Protection for putting those provisions into the home rule charter, and that case is currently pending.
Yeah, it sounds like you can.
So again, worst case scenario, and the only caveat is to say that the reason for the sanction was different, I think, in some ways from future cases that would be brought. The case was very aggressive. We countersued the oil and gas company. The oil and gas company sued the township. We countersued them. We countersued them on the theory of the right of local community self-government. Judge Baxter was not happy with that countersuit and let that be known through the sanctions award. We've hired other outside counsel to actually appeal the award, and we think there are grounds to do so. But that's, to expect the oil and gas industry. Judge Baxter was responding to the oil and gas company's motion for sanctions. That sometimes gets lost as well. It wasn't Judge Baxter standing up to say, I'm doing this unilaterally. It was the oil and gas industry that made a motion to force us to pay $500,000 in attorney's fees. That's what the oil and gas company made a motion for against us. That was the original motion. She granted $52,000 in fees against me and a co-attorney, and did so because she found our arguments not to be plausible, that the people of Grant Township shouldn't and don't have a right of local community self-government to say no to a frack wastewater injection well being imposed in a community. That's the basis of it.
So I have 2 questions. Okay. This is my second question. Our counselors say that we can rely on a new governor and new elected state legislators. Do you know of any elected officials who have confronted industrial assaults on other communities and states? And if so, what did they do and what was the outcome?
You mean state officials?
State officials.
New York State.
There have been smatterings in different places, but not really around the Community Bill of Rights stuff, except for New Hampshire, where the legislature has picked up, some of the legislators have picked up movement of the state constitutional amendment. There's been very little protection for these communities moving forward, and that's something that has to be remedied in the future. The good news is there's some elected officials at the local level who are moving up the ladder, who were supporters of community bills of rights and are now in the legislature, state legislatures who are trying to do similar things, but it's still pretty sparse. I think one of my favorite elected officials is John Olivas, who is the chairman of the Mora County, New Mexico Board of County Commissioners. Became the first county in the United States to ban fossil fuel extraction, hydrocarbon extraction within the county of Mora. And for their work, they were sued twice. By the oil and gas companies who came in and overturned the ban on hydrocarbon extraction within Mora County. So, there are some higher officials, but there are very few as far as.
Do you know the story in New York City, or in New York State? Do you know about what happened there very much, or you're probably acquainted with it, aren't you?
Right, a little more detail is needed on that one.
I don't have the time to go into that.
Big state.
I just wonder what the grassroots effort was there. Because brother, it sure had some effect. And I know the governor, I mean, you know, he took it and ran with it and shut it all down. But, you know, I just would like to know what was going on there. And if anybody knows something about it, I wish they'd explain it to me.
Yeah, I think you mean the fracking stuff.
Yeah.
That happened there. Yeah.
He banned it.
The fracking stuff was actually driven by two small towns in New York who decided to ban oil and gas extraction within their municipalities. So the whole state response to that and the grassroots organizing was actually first around those two small towns. So it all happened locally and then built its way up through the political process. And the governor has other political ambitions too. And so it was a sausage making at its best, where they arrived at the very end of that thing. So anyway.
That's good.
And it's a temporary ban.
Yeah.
It can be overturned by the next
I know,
governor.
till the next guy gets voted in.
So it seems like we're talking about sort of two strategies. There's the regulatory approach, which is we're still going to get raped, but we'll do it in a slow and safe way. And then there's like then there's the rights-based approach. I want to know, why can't the city declare a state of emergency? There's so much scientific evidence that climate change is real. We're the cause of it. It's happening. So there must be some precedent where a town or a city can create a state of emergency for a very good reason. The end of the planet seems like a real emergency. So why can't we do something like that and be bold and bring in scientific evidence, right, and all of that data? I mean, I haven't read any studies that prove that fracking is safe, but, you know, I get online and I'm bombarded with hundreds of things telling me all the bad things about it. So why can't we declare a state of emergency? Because I think we do have a real emergency.
Yeah, that's a good point.
Sure. I mean, in my world, I would support a state of emergency, but unfortunately, municipalities generally may declare emergency to pass emergency legislation to bypass procedural requirements for passing ordinances and that kind of stuff. I'm not aware of any authority that would allow a blanket emergency situation to allow that kind of thing to be done. But I don't know Colorado law, so there may be something there that's needed. Sorry, not a very good answer. I know.
And there was a woman who asked me, why can't we just sue the state? Because she wasn't able to ask this question. So.
It's a good question.
How much money you got?
It sounds like
sue the
right,
CRGCC,
it's an
though.
issue of civil rights that
Sure we can.
you should sue rather than get sued by that
That's what
person with that corporation.
That would make sense, wouldn't it?
Yeah, there's a loophole, I'm sure. Absolutely.
I just wanted to give Mayor Bird a chance to answer my second question, which was about the criteria in the decision-making process.
So this is Mr. Lindsay's night, and when we have a full council, you're welcome to come. And I'm not going to address, I don't speak for the council doesn't speak for me, we're all individual voters on the council, so I'm going to reserve that for a full session.
Some the caboose. Thank you for coming out. If you'll indulge me for a second, I'd like to give you a little background. I was born and raised in West Virginia, and I know what industry can do to land, air, and water. And if we're aiming to be like Oklahoma, who had 240 earthquakes in a calendar year due to fracking, it's disgraceful. We can't get our own way.
What part of West Virginia?
Huntington.
Yes. I grew up in southwestern Virginia, close to Bluefield.
But, you know, as far as a river, the Kanawha River goes right through the state capitol. And within a 5-mile range, you've got Monsanto and DuPont dumping toxic soup into the the Kanawha River caught fire like the Cuyahoga. And it took 35, 40 years to clean it up. And now it's all been turned upside down and they're allowed to dump in the rivers again.
There you go.
So I hope you stay with us and support us, help us. Please, will you? Thanks.
As you. Just coming to West Virginia, it was one of my first experiences with wide-scale environmental destruction was mountaintop removal in West Virginia, where they've taken the tops off about 150 mountains at this point. And then the environmental groups made a movie called The Last Mountain, because really there's not many mountains left. And I always thought to myself, I don't want to be making that movie, The Last Mountain. You know, it's but that's what a lot of environmental groups do. You know, so they make movies about the last mountain. Well, we got to move beyond that and find a way to stop them from being decimated in the first place. And I think this is part of that story.
Who's been there with us for so long. East Boulder County United meetings are in Lafayette at Vitamin Cottage every second and fourth Monday of the month. We do not anticipate the City Council will do the right thing. So we have to start making plans on that basis to really create a fight to protect Lafayette. So once again, thanks everybody for coming out.
How long have you been volunteering doing this? What's that? How long have you been volunteering?
It depends on how loose you want to use the definition of volunteering. I've known Cliff for 10 years, and I've been involved in this, in some form or fashion since we got involved, but not nearly as energetic and robust as him.
Yeah, right, sure.
Okay.